One of the returning pleasures of life as a corporate lawyer is having to read through tons of non-disclosure agreements or NDAs. These are agreements between two or sometimes more parties that aim, to hit as in the name, to protect information exchanged between these parties. So typically what is being stipulated are things like what is protected information, how does it have to be protected, can it be shared with third parties, yes or no, and for which purpose can it be used? And that's typically it. These agreements are typically plain vanilla, box standard, over-the-counter commodity products. Except sometimes they aren't. Quite often I read through non-disclosure agreements that go beyond these relatively simple dimensions and add another layer of stipulations. Just a few days ago, I stumbled across one that was a so-called two-way non-disclosure agreement, so it protected information of either party given to the respective other party. Except for one small stipulation that was unilateral. And that said that if based on such information being transferred, IP is created, such as a copyright or invention being made, then the receiving party, and that's only one, has a license, a right of use to such IP. Now, that should not be in there, I feel. I'm not saying that there is not a bunch of situations that I could think of where such a clause would make sense. In the trade, we call this information pollution or IP pollution. But these situations are highly specific and very narrow, and they should not be covered in a blanket, cover-it-all non-disclosure template agreement. And there are three reasons why you should be very careful in putting such unexpected and sometimes a bit sneaky clauses into your NDA. The first one is, as I said, an NDA is a plain vanilla agreement. Don't waste 1 hour of my time in making me read it and understand what it actually does. The second is, these additional stipulations typically don't work. Think of this license I just mentioned. A license should be negotiated completely independently of the exchange of information and should be highly tailored. It's typically highly specific. A price needs to put on there. You can't just put that as a template in an NDA. It just doesn't work in terms of the business you want to do. But the third reason, I think this is the most important one, is that you completely misunderstood what an NDA does. An NDA typically is the first contractual touch point between two parties. It establishes a framework under which information can be exchanged to then reach a certain business goal. An NDA is not an end, it's a means. And the idea is to establish trust. Now, if you put clauses in an NDA that are outright sneaky, that is the opposite of establishing trust. So instead of greasing the machinery, what you just did is you put sand in the cogwheels of the machinery. So don't do that.